speaker for tonight. Her name is Emily Milstein, and she is an attorney with Contra Costa Senior Legal Services. I'm sure many of us have heard about their services and what great work they do in our community. So Emily, we are very happy to have you tonight, and please take it away.
Thanks, Samantha. Hi, everyone. My name is Emily. I'm going to start sharing my screen. I have a PowerPoint for all of you. And give me one sec. Okay, so my name is Emily, and I'm a staff attorney at Contra Costa Senior Legal Services, and I handle all of the elder abuse cases for Senior Legal Services. So I pretty much spend all my days doing elder abuse restraining orders, which is what we're here to talk about. So first, a word about Contra Costa Senior Legal Services. We provide free legal services exclusively to Contra Costa County residents who are age 60 and older. We do elder abuse, but we also do work on preservation of housing, such as tenants' rights and eviction defense. We handle consumer issues such as debt and scams. We do advanced planning and prepare free advanced healthcare directives and powers of attorney. And we can help with public benefits issues such as Social Security, Medicare, etc. So here are some key acronyms for the presentation. First and most importantly, we have elder abuse restraining order. We have domestic violence restraining order, civil harassment restraining order, temporary restraining order, just plain restraining order. And then we have the Elder Abuse and Dependent Adult Civil Protection Act, which is the main statute for these elder abuse restraining orders. So as you can probably guess from that, we have a few different types of restraining orders. First, obviously, is the Elder Abuse and Dependent Adult Restraining Order. Next, we have the Domestic Violence Restraining Order. And unlike the Elder Abuse Restraining Order, the Domestic Violence Restraining Order requires that there be a special relationship between the parties. And so this can include parties who are married or who are registered domestic partners, parties who are divorced or separated, people who are dating or used to date, people who have children together, or some other family member or close relationship, such as in-law or parent. Then we have a civil harassment restraining order, which is for parties who do not have this close relationship, such as a neighbor or a roommate. And then we have criminal protective orders, and these are just basically issued for criminal cases to protect the victim. And lastly, we have emergency protective orders. And these are short-term orders that the police can request for people who are in danger and need some immediate protection. The length of time that these can last varies. It can be a week, it can be a month. It really just depends on the seriousness of the situation and how much danger the police believe the person might be in. These emergency protective orders, they can be great for clients because they protect the client right away and give the client time to seek a more permanent restraining order. But with these restraining orders, it can make it challenging to serve the other party, because when your client gets this emergency protective order, usually the other party disappears. But we'll talk more about this later. So next, I want to talk about some of the risk factors for elder abuse, because this will help you screen your clients for elder abuse. One of the biggest risk factors for elder abuse is social isolation. And when we talk about social isolation, what we mean is a lack of social connection with others. Being socially isolated increases a person's risk of elder abuse, because that person is more likely to lack necessary social supports. And when a person lacks these social supports, it's a lot easier for a caregiver or some other individual in the elder's life to step in and start abusing the elder. Social isolation can cut seniors off from resources and from the people who can help support and protect the elder from this abuse. I once heard an awful story about a senior in Contra Costa County who was talking to scammers on the phone and kept talking to these scammers. And the senior knew that these were scammers that they were talking to. And the senior's spouse even begged the senior to stop talking to these scam artists on the phone, but the senior wouldn't stop. And it turned out that the senior was talking to the scam artists because, as the senior put it, these scammers were the only people who would talk to the senior. Nobody else, the senior felt like, was supporting her, was in her life, was giving her the time of day. And so this shows how isolation and loneliness can really make a person more vulnerable. And many people are isolated because of the loss of family or the loss of physical or mental capacity and the loss of family or friends. And these physical and mental impairments and this lack of physical or mental capacity are another risk factor for elder abuse, because the lack of mental capacity, such as dementia, is probably one of the biggest, if not the biggest, factors for elder abuse. Studies have shown that almost half of people with dementia experience some kind of abuse or neglect, and people with these mental and physical impairments are at higher risk because they can't take care of themselves and they rely on others for care and for the necessities of daily life. In addition to being vulnerable, many seniors who are victims, they remain silent about the abuse. They might think that there's nothing that can be done to rectify past abuse. They fear retaliation. They fear that they won't be believed. They might also fear that their independence and control will be restricted or taken away. They might a lot of times remain silent to protect abusive family members from the legal consequences of their crimes. Or the senior might be too embarrassed to admit that they've fallen victim to predators and to abuse. And if the abuse is extreme or prolonged, the elder might even start to identify with the abuser and then have trouble kind of understanding what's abuse and what's not. So next, we're gonna talk about who experiences elder abuse. And similarly with domestic violence, seniors across all socioeconomic groups, cultures, and races can be victims of elder abuse. Women are 66% more likely to be affected. And as I mentioned, elders who lack capacity are more likely to be victims of elder abuse. And then in almost 60% of elder abuse and neglect incidents, the abuser is a family member. And then, so during the COVID-19 pandemic, there's been some evidence that elder abuse has been rising. And unfortunately, elders are at higher risk now because of COVID-19, but the measures that we've put in place to protect those older adults from COVID have also put those seniors at higher risk for elder abuse. And these include social isolation, financial hardship, a heightened reliance on family caregivers, and increased stress in the household. And these are all risk factors for elder abuse. And unfortunately, for many seniors right now, these seniors are disconnected from their usual social activities. And there's evidence that elders who suffer from mental health issues like depression are at higher risk of abuse. And right now, because of COVID, many seniors feel more isolated. They feel stressed about getting sick. And this makes their mental health more vulnerable and puts them at higher risk of abuse. And then we also know that the increased burden on caregivers, which can go hand in hand with increased stress in the household, this stress on caregivers can also increase elder abuse. Caregivers might feel more burdened right now because they've lost some of their income, or maybe their family members are sick, or maybe they have kids at home who are doing remote learning. And these burdens can make it harder for caregivers who struggle with substance use disorders. Those caregivers might be more likely to use those substances now, and people who have substance use problems are more likely to commit elder abuse. This has been shown to increase the risk of abusive behavior by caregivers. So next, the key statute that we're talking about tonight, as I mentioned, is the Elder Abuse and Dependent Adult Civil Protection Act. And that is Welfare and Institutions Code sections 15,600 through 15,675. And so now let's really start talking about elder abuse restraining orders. First, we need to talk about who qualifies for these restraining orders. Adults who are 65 years or older, they qualify automatically. And for those of you who work with elders, it's likely that most of your clients will fall into this 65 and older category. The second way to qualify is to qualify as a dependent adult. And so what is a dependent adult? It basically means that it's someone who is between the ages of 18 and 64 years who has some sort of physical or mental limitations that restricts that person's ability to carry out normal activities or protect his or her rights. And this doesn't tell you exactly what degree of physical or mental limitation the person should have to qualify, or how restricted that person's ability to carry out their normal activities should be. And of course, there's a huge spectrum of this and how limited or not limited people can be. Then there's another criteria for what could be a dependent adult, and that's basically any person whose age, again, 18 to 64, who's admitted as an inpatient in a 24-hour health facility. And because these definitions are a little vague, there's been some case law that has helped flesh out this definition a little bit. One case for this is Estate of Schinkel. And this case basically says that for a person to qualify as a dependent adult, that person must need help with activities of daily living, like cooking, bathing, banking, etc. And then there are some other cases as well. And these cases are a little bit more limiting in terms of what qualifies as a dependent adult. Just because a person has some limitations or a disability doesn't mean they can qualify as a dependent adult. And conversely, just because a person does not live in a care facility doesn't mean that they're not a dependent adult. You can be a dependent adult and not live in some kind of 24-hour care facility. And practically speaking, I've only ever had one client who I ever needed to even try and qualify as a dependent adult. And the judge in that case was the commissioner in Martinez, who hears most of these elder abuse cases. And the commissioner had never even heard of this provision of the law, didn't know that dependent adults could qualify for this restraining order, and didn't know what a dependent adult was. And so if you have a person who you want to qualify as a dependent adult, you should have read the case law. You should be ready to educate the judge on what is a dependent adult, because the judge might know nothing about this. And in my case, I had printed out a copy of the statute of what a dependent adult was, and I was able to just hand that to the judge. And In my case, the judge ended up ruling that my client was a dependent adult. And I had had doubts that this client would qualify. And I think the judge mostly just ruled that the client was a dependent adult because the judge hadn't read these cases and didn't really know anything about this and didn't know to question me on this. So it can work out in your favor if the judge doesn't know what a dependent adult is. And then, so next, I want to talk about the different burden of proof across the different types of restraining orders. With an elder abuse restraining order, the burden of proof is a preponderance of the evidence. And there's a case called Bookout v. Nielsen, and that's the case that held that preponderance of the evidence was the standard, the burden of proof for these elder abuse restraining orders. And in that case, the court rejected the argument that the standard for elder abuse restraining orders should be the clear and convincing standard. And that clear and convincing standard is used in civil harassment cases. And then in domestic violence cases, the standard is also a preponderance of the evidence. So if you can get your clients to qualify for the elder abuse restraining order or the domestic violence restraining order, that's great. That's usually where I steer my clients to, and usually for people who work with seniors, most of your clients can fall usually into the elder abuse or domestic violence restraining order categories. So next, what is required to get an elder abuse restraining order? Now, the court may issue protective orders to prevent a recurrence of abuse on reasonable proof of a past act or acts of abuse of the petitioning elder or dependent adult. And with or without notice, it can be with or without notice, and this just refers to the availability of obtaining a temporary restraining order before notice in a hearing. So these are issued ex parte, and even if a request for a temporary restraining order is denied, you'll still get a hearing that'll be set out usually about 3 weeks from when you apply for the temporary restraining order. And a petitioner is under penalty of perjury, and it's best to get all the facts of your client's case out when you first apply for the restraining order, so that the judge then has those facts in front of her when she hears your case. When we prepare a request for an elder abuse restraining order, we like to attach a declaration, and that prevents all the most relevant facts in your client's case. And this declaration and your client's testimony can be sufficient evidence for a judge to issue an elder abuse restraining order. You can submit additional evidence, but you don't necessarily have to. I've had plenty of cases where I don't submit any additional evidence, and the judge will issue the restraining order based on the declaration that you submitted and your client confirming under oath that everything in the declaration is true. You can submit additional evidence, such as a police report or photos, if you have them and if you want to. You just need to bring 3 copies of all your evidence to court with you, one for the judge, one for you, one for the respondent. And there's no discovery in elder abuse restraining order cases, unlike with other types of cases, because there just isn't time. And usually there isn't any need to do discovery in these cases. So additionally, to get an elder abuse restraining order, you don't need to show that there's any threat of future harm. An elder abuse restraining order can be issued on the basis of past abuse alone. And it's good to know this because sometimes judges don't know this, and you want to be able to correct the judge, or the judge will deny you for not showing that there is or will be future harm. And then, as I mentioned earlier, the parties do not need to have any special relationship to qualify for an elder abuse restraining order. Next, I want to change tracks a bit and talk about what types of abuse can constitute elder abuse. And so the one that might be most obvious is physical abuse. And this doesn't just include an elder being hit or pushed. It can include some kind of inappropriate restraint, the deprivation of food or water, the misuse of medication, which can be over-medicating or administering drugs for a purpose that's not authorized by a physician, such as for some kind of punishment or restraint. Then you have sexual abuse, which is basically just non-consensual sexual activity. You have mental suffering, and this is a common one. I get a lot of clients who come to me and say, oh, I'm being mentally abused. And sometimes it is abuse, sometimes it's not. And mental suffering means fear, agitation, confusion, severe depression, or other forms of serious emotional distress that are brought on or is brought on by forms of intimidating behavior, threats, harassment, or deception, or misleading statements that are made with malicious intent to agitate, confuse, frighten, or cause severe depression or emotional distress in the elder or dependent adult. Next, we have neglect or abandonment, which are pretty much what they sound like. And then isolation of an elder. And isolation of an elder is an insidious tool used by abusers, and with the systematic exclusion of all outside contact, the elder victim is usually driven to distrust friends, doctors, or even close family members. And ultimately, the elder victim becomes a pawn who's manipulated into trusting only the abuser and no one else. And so one of the warning signs of isolation is if the elder's contact with others, including family, visitors, doctors, clergy, other friends, if that contact is being restricted and the elder is not given the opportunity to speak freely or to have contact with others without the caregiver being present. Next, you have deprivation of care. And deprivation of care is a pretty common form of elder abuse. And it means the deprivation of care by a care custodian or caregiver of services or goods needed to avoid harm or mental suffering. And goods and services necessary to avoid physical harm or mental suffering includes, but aren't limited to, medical and mental health care, assistance in personal hygiene, adequate clothing and shelter, protection from health and safety hazards, protection from malnutrition, and the transportation and assistance necessary to secure any of these needs. So that's like driving the elder to the doctor or to pick up their medication at the pharmacy. And you might need to prove that the respondent is a caregiver. The Elder Abuse Statute provides a long definition of what is a care custodian with tons of examples that you can look up if you need to. But the statute also has a catch-all that includes just other people who care for elders or dependent adults. So it's pretty broad. There's definitely room to argue that someone is a caregiver. Next, we have financial abuse. And this basically means the illegal or unauthorized or improper use of an elder's money, benefits, belongings, property, or other assets or resources for the benefit of someone who is not the elder. And this can include financial neglect as well, like not paying an elder's electricity bill, such that the elder's lights get turned off and the senior is left sitting in the dark. Financial abuse can be tricky because it can be difficult to establish the intent to abuse. For example, if you have an elder who gives her son and daughter-in-law $20,000 to help them with financial challenges, with the understanding that the elder would be moving in with them and they would take care of her. Now that the elder is in hospice, the family and the son and daughter-in-law tell her they can't care for her any longer and they can't afford to repay the money, which was also not explicitly designated as a loan. Is it financial abuse? Can it really be shown that they intended to trick her out of her money? Or is it just a case of family members being overwhelmed by the responsibilities of caring for mom? Sometimes it's a gray area, but financial abuse is extremely common. So if you work with elder abuse, you will definitely encounter financial abuse in your practice. And then lastly, we have abduction, and then there's a catch-all in the statute, which is other treatment that results in physical harm, pain, or mental suffering. So next, I want to just mention some signs of elder abuse. If the senior stops participating in activities that the elder once enjoyed, if the elder looks messy or unkempt, or has trouble sleeping, or unexplained weight loss, or becomes withdrawn or agitated or violent, if the senior displays signs of trauma, such as rocking back and forth, or has unexplained bruises or cuts or scars, those are all signs of elder abuse. As are if the elder has broken eyeglasses or frames, or shows some kind of sign of punishment or restraint, if the elder develops bed sores or some other preventable condition, if the senior lacks medical aids such as glasses or a hearing aid or medication, the senior lives in a hazardous, unclean, or unsafe living conditions, if the person receives an eviction notice for unpaid rent or a notice of a late mortgage or home eviction, or shows some signs of insufficient care or unpaid bills, despite the fact that the elder has adequate financial resources. All of these are signs of elder abuse, and if you encounter them, you can know perhaps to try to investigate a little more and figure out what's going on with your client. And so next, who commits elder abuse? You have family members. This is a really common one. I would say a huge percentage of my elder abuse clients, they come to me because their adult children is abusing them. I see a very common fact pattern with seniors who have an adult child that has some combination of mental illness or substance use disorders, and the parent invites the child to live in the parent's home, and the child's own issues cause them to lash out and make life difficult for the elder. I'd say a good, third of my cases have that fact pattern. And then the other big one to be aware of is scam artists commit elder abuse. And unfortunately, though, restraining orders can't help with scams. But so in Contra Costa County, during the 2019 to 2020 years, there were 5,423 elder abuse allegations made to APS, and financial exploitation was the second most common allegation, then neglect, followed by psychological or mental abuse. And I thought this was surprising because I thought physical abuse would be more common, but it's not. And it's not on this slide, but the most common allegation was actually self-neglect, which was very interesting to me. So next, who can seek an elder abuse restraining order? And so most obviously, the elder or dependent adult can seek this, but also a conservator or a trustee of the elder or dependent adult, an attorney in fact for an elder or dependent adult who acts within the authority of a power of attorney, a person who's appointed as a guardian ad litem for the elder or dependent adult, or some other person who's authorized to seek a restraining order can do it. And then adult protective services can also, under certain circumstances, seek an elder abuse restraining order. And they can do, APS can do this if the elder or dependent adult has suffered abuse and that elders has an impaired ability to appreciate or understand the circumstances that place that elder or dependent adult at risk of harm. And the elder or dependent adult must also have provided written authorization to APS, allowing APS to act on that person's behalf. So next, I want to change tracks a little and talk about what an elder abuse restraining order can do. And first, we have a category of orders called personal conduct orders. And this includes two different things. It can include a stay away order. And, it can include a no contact order. And basically what this just means is that the restrained person can't have any contact with your client. The elder abuse restraining order form has an option where you can select no contact, but you can also, if your client wants some contact, you can kind of choose whatever contact your client wants. So you can tell the judge, my client wants the restrained person to be able to call her once a week, or the parties can communicate by handwritten letters or by email. It's basically whatever your client wants in terms of future contact. And then the other kind of personal conduct order is an order that the restrained party can't abuse your client. And it includes this long list of things they can't do: physically abuse, financially abuse, intimidate, molest, strike, stalk, threaten, assault, sexually or otherwise, hit, harass, destroy the personal property of, or disturb the peace of the person. So it's pretty broad. And pretty much every elder abuse restraining order I do, we request that there be no physical, financial abuse, etc. Those are all lumped together on the elder abuse request form. And then the next category of orders that you can get are stay away orders. And with this, your client gets to choose a certain number of yards, and that's the distance that the restrained person has to stay away. I often choose 100 yards. Sometimes the client wants 300 yards. It's really just what your client wants, and based on the facts of the case, what's reasonable. I've never asked for more than 300 yards because you don't want to ask for something unreasonable that's going to be overly restrictive on the restrained person. And you can ask that the restrained person has to stay that distance away from the elder or dependent adult, from other protected persons, and the restraining order allows you to add additional people who need protection. So sometimes you can add your client's caregiver as someone who also should be protected by this restraining order. You can also ask that the restrained person have to stay away from the home, the job or workplace, or the vehicle of the elder or dependent adult. And then there's another option on the elder abuse form for other, and you can check this if maybe your client has a religious building that they go to often, or another family member's home that they're often at, and they want the restrained person to have to stay away from this additional place. And so next, an elder abuse restraining order can get a move out order. And this is where you ask the court to order the restrained person to move out of a particular residence where your client lives. And this order is a little bit tricky. There are some requirements for it. The restrained person must have assaulted the elder or dependent adult in the residence, and the elder or dependent adult must have a right to live in the residence. And the second requirement is important because sometimes you get clients who want an elder abuse restraining order and they want someone to have to move out of that person's home. But the home that the client wants the restrained party to move out of is not the client's home. It's not a home where the client lives or owns or really has anything to do with this home. Sometimes you'll get a client who's a tenant in maybe the downstairs unit of a house, and the landlord in the upstairs unit is the abuser, and the client might ask you for a restraining order to make the landlord move out of his upstairs unit. But a judge can't order a landlord to move out of, one, a separate unit where the client doesn't live, and two, if it's the landlord's home, a judge won't order a landlord to move out of the landlord's own home. There's a case, Harriet v. Harriet, that basically says that a court can make a restrained party move out of basically the dwelling where the protected party lives. So if you have one apartment where both parties live, then the protected party can get an order ordering the restrained person to move out of that single apartment. But if you have an apartment building and your client lives in apartment A and the restrained party lives in apartment D, a judge is not going to make the restrained person move out of apartment D. They can't do that. And then, so for the move out order, there's some considerations and various things you need to think about. Judges don't always grant move out orders. Sometimes you might get an elder abuse restraining order, and it might have conduct orders, it might even have a stay away order, but the judge will deny the move out order. And this means that your client has a restraining order, but they continue to live with the abuser. And clients need to be advised that they can ask for the move out order, but they might not get the move out order, and they might be stuck living with the client. And usually clients are obviously, understandably unhappy about this. And so it'll make your job easier if your client knows this might be something that happens. And then it can be difficult to get a move out order if it's verbal abuse only, or if it's relatively minor abuse. Judges, we think at my organization, we think judges are wary of people using the restraining order process as an alternative means of getting an eviction, given that it's hard to get evictions right now. There are all sorts of protections for tenants. We've had clients come to us and say that they want an eviction, they can't get the eviction, so they want to get a restraining order as a way of achieving getting the other person to move out. And judges are wary of this. And so the clients need to be aware of this too. You should consider discussing eviction as an alternative to an elder abuse restraining order if you get a restraining order with no move out. it can be easier to get the move out order if there is physical violence or threat of injury or some other type of violent behavior. And so lastly, the elder abuse restraining order has a provision where it can grant possession and protection of animals to the protected party. And I've had clients who actually, they actually ask for this. And basically you just need to be able to describe the animal and say what kind of animal it is. And then I had a client who had a service animal, and the client's adult child took the service animal away. And we filed for a restraining order that asked for the client to be given possession of the animal. And the judge, in fact, gave us a temporary restraining order saying that the animal needed to be given back to my client. And so it was a great outcome for the client. And you can also ask the restrained party to stay a certain distance away from the animal. And you can ask that that other party not be able to harass or abuse or hurt the animal or sell the animal or transfer the animal. And then lastly, you can, on a restraining order, ask for other additional orders that the client wants. This can be useful for financial abuse cases. For example, we had a client who was taken to a car dealer by an adult relative, and the client couldn't drive, but the adult relative took the client to this car dealer and had the elder buy a car. And then after this, the adult relative took the car and left the elder at home, and the elder never saw the car again. The elder couldn't drive, had no way to use this car. And so we were able, by filing a restraining order, we got the relative to surrender the car so that the client could get their money back. Often a client won't need any additional orders, but it's good to keep in mind if your client wants something that's not among the standard orders for these restraining orders. So the elder abuse restraining order, there are certain things it can't do. It cannot recover money, though attorney's fees are available. So if you have a financial abuse case and your client's lost a lot of money, while a restraining order might not be a bad thing to have your client get, it won't recover that money, and you need to think about some other means to get that money back. Additionally, the state added a provision to the elder abuse restraining order form that could be used to order the restrained party to undergo some kind of counseling or anger management sessions. This is something that elders, my clients, often want for the other party. The problem is nobody really knows how to enforce this. This is something that's relatively new to these restraining orders, and I've communicated with other people who work in this field, and from what I can tell, this provision isn't really used. Courts don't really know about it. Nobody knows how to enforce it. One option could be that you ask the trial court to set a review hearing to inquire about whether the restrained party is complying with these court-ordered counseling sessions, or you could try to use, hold the restrained party in contempt if they get the court to do that, if the restrained party doesn't follow through. But unfortunately, unlike with domestic violence restraining orders, there's no good mechanism for getting counseling for the abusers. So if you're going to file for an elder abuse restraining order, there are various forms that you'll need to fill out. First, and most importantly, is the EA 100, and this is the main document that you use to request an elder abuse restraining order. It's the document where you can attach your client's declaration to it and where you explain what the abuse is and what's happened with your client. and you explain what your client wants. Like, does your client want a move out order? Does your client want a stay away order? That sort of thing. You also will need to submit, along with the EA 100, you need to submit an EA 109 and an EA 110 to the court. And these first three forms will comprise your restraining order application. And then two additional forms, the EA 120 and the EA 120 info. These are forms that are given to the restrained party when that party is served, and this allows that restrained party to respond to your client's petition. And then you have the EA 130, and that is basically the permanent restraining order. That's when you go to your hearing and the judge gives you a restraining order. It's this EA 130 form that the judge will fill out. And one little tip is, if you have a elder abuse restraining order hearing, before you go, you can print out this EA 130 and fill out the very basic information like the parties' names. And then you can take it to the hearing and give it to the judge at the end if you get a restraining order, or you give it to the clerk. So the clerk can fill in exactly what the judge ordered. And they like it when you do this because it makes their lives easier. So for the restraining order process, the first step is you request a temporary restraining order and you submit those three forms that I mentioned on the last slide to the court in Martinez, and the judge in Department 57 there will review them. And then that same day, the judge will decide whether to deny or grant the TRO, and the judge will schedule a hearing date, which is usually about 3 weeks later. And there should be no fees to file. Occasionally, the court will make a mistake and charge. I've heard about charging people to file these. So if you have a client who is asked for a filing fee, that's wrong and you should say something. Next, you have to serve these this restraining order application, and you have to personally serve the respondent by someone who's 18 years or older with the TRO and the form to allow the restrained person to respond to the TRO. That was the EA 120 form. And you have to serve the respondent at least 5 days before the hearing. And then the server will need to fill out and sign a proof of service. And then the requesting party has to file this proof of service with the court before the hearing. What I usually do is have the sheriff serve my restraining orders, and the sheriff is great because they do this for free, and they have their own proof of service, and they will file that proof of service with the court for you, and the sheriff will enforce any move-out orders that your client gets. So they'll show up at your client's house or wherever the other party is, serve the documents, and make the other party move out right then and there. And service of process can be an issue for these restraining orders. Sometimes the respondent is homeless. It's really hard to serve a homeless person. Sometimes if your party gets an emergency protective order, or if your client gets an emergency protective order and the respondent has disappeared, you can't find them, and it's really hard to serve those papers. And then just lastly, the responding party can file a response. I've never really had respondents file responses in my case. People don't usually bother with that. So next you have your hearing, and the judge will proceed with your restraining order hearing only if personal service was completed. The judge can grant you a restraining order that lasts up to 5 years. Usually they'll make it last for a shorter period of time, sometimes 6 months, sometimes 3 years. If your client wants something specific, feel free to ask for 5 years or 2 years, whatever your client wants. The respondent is entitled to 1 continuance, and you can make sure to bring that EA 130 form for the clerk to fill out after. So then, if personal service was not completed, the judge will continue the hearing. But the good thing is that the TRO will be reissued, and the TRO will be good until that new hearing date. And then if your client is the requesting party and the client is a no-show, the TRO will expire that day, and the case usually will be dismissed, though you can ask for a continuance if you're there as the requesting party's attorney. And as I mentioned earlier, the burden of proof is the preponderance of the evidence. So these restraining orders can be renewed, and you can request that they be renewed within the 3 months prior to the restraining order's expiration date. And you should put this on your calendar, because once the restraining order expires, you can't renew it. You have to go through the whole process and start all over again. You have to prove that your client has suffered some harm, and you have to prove that your client needs the restraining order, just like you did when you got the first restraining order. And to renew the restraining order, there's no showing of new abuse necessary. The order can be made for 5 years, or it can be made permanent. And as I mentioned, once it's expired, no renewal is possible. And you have to support that new application with evidence of new abuse. And this can be hard if your client has had a restraining order that's been adhered to and there hasn't been any abuse. And in that case, you can try to show that there's ongoing risk to your client and why they need the order because of that. Next, I want to just talk a little bit about settling an elder abuse restraining order case. In my organization, we rarely settle these restraining order cases. Often the restrained party is not really in a position to settle the case. A lot of times that restrained party has some kind of mental illness or substance use, or that restrained party is just disengaged and hasn't really been a part of this whole process, and they're not around for you to talk to and negotiate. Your client might be frightened of going to court, in which case maybe then it might be good to consider settling the case if your client really wants to avoid court. But for cases involving physical violence, settlement is not really appropriate. And so I've only ever had one case that's settled in my time of doing this. So, yeah. So next I want to talk about some additional things to consider. When your client, if your client gets a restraining order that contains a move-out order, usually if the sheriff comes to enforce that move-out order, or whoever enforces it, the other party, the restrained party, has to leave quickly. The sheriff doesn't give them time to gather up and pack up all their things. They just knock on the client's door and kick the other party out. And so that means that all the restrained party's things are left in your client's house. So I get a lot of questions from clients about what to do with all this stuff that belongs to the other person. And you can refer to these sections of the California Civil Code that I've listed. They lay out a process for dealing with abandoned property. This process, unfortunately, is confusing for clients. It's a little cumbersome. It's not a great process for elderly clients to have to deal with. So I usually just advise my clients where if they can, they should somehow get in touch with the other party and let the other party know that the other party should arrange a time to come and pick up their things and get their things out of the client's house. And if the client's scared for their safety, they can have the police come as part of a civil standby to protect the client while the restrained person comes and gets their things. when the police do this, they don't come for very long. So if there's a lot of stuff, you should tell your client to have it all packed up and ready to go, because that'll minimize the amount of time that the restrained party has to spend in the client's home. You can also raise this issue of abandoned property at the hearing to the judge, and sometimes the judge will be happy to make an order on this or tell the other party, go and get your stuff, that sort of thing. So then the other thing to consider are there can be challenges to enforcing elder abuse restraining orders. So the police are the ones that enforce these restraining orders, but unfortunately, police responses vary by city. Some police do more than others to enforce these restraining orders. And in cases where your client gets an elder abuse restraining order, but continues to live with the other party or live in very close proximity to the other party, there's not a lot the police can necessarily do to enforce the restraining order. Your client can call the police if there's a violation, but if the abuser leaves before the police get there, then the police won't do anything. Your client can go to court and seek a contempt order for repeated violations of the restraining order if your client documents these violations and files police reports, but this is very rare. There can also be criminal cases brought against repeat restraining order violators, but this is also pretty rare. And sometimes clients have concerns about the police and about safety, and they don't necessarily want to have to call the police to enforce the restraining order. And so with these clients, often what I'll do is maybe suggest another community local organization, like the Family Justice Center is an organization in Contra, Costa County that works with victims of abuse. Maybe have the client reach out to them for advice on enforcing the restraining order. And if the client doesn't want to call the police themselves. So next I have some local tips for these restraining order cases. You should be prepared for varying styles at the hearing, like varying judicial styles. You might have the commissioner in Martinez who hears a lot of these cases. You might have a different judge, you never know. And different judges will have different preferences and different levels of knowledge about elder abuse. Some judges, they might want a lot of testimony. Some judges might want a little bit of testimony. Other judges will just accept what's written in your declaration, in your client's declaration, and have the client confirm that everything is true. Some judges are more concerned about the rules of evidence than others. Sometimes the judge will just look at whatever police report you brought in and not bring up issues about hearsay or anything like that. Usually, I think the rules of evidence are more relaxed for these restraining order cases than in other types of cases. Also, elder abuse restraining orders are usually heard at the same time as civil harassment restraining orders. And those civil harassment restraining orders have a higher burden of proof. So you should make sure that the judge knows that the elder abuse standard is different than the civil harassment standard, because you don't want your client to be held to the higher standard unnecessarily. You should also try to prep your client as much as possible, because it's often the case that no other evidence is available beyond the client's testimony and the client's declaration. So some additional tips. In my cases anyway, the restrained parties usually appear pro per. I've never had a restrained party come to court with a lawyer. And often those restrained parties, or sometimes those restrained parties, they don't even appear. And so it's just you and your client at court. And usually when it's just you and your client, the hearings are very short. The judges don't ask a lot of questions, and I've had hearings that lasted only a few minutes. For clients with disabilities, as I'm sure you all probably know, it's good to request that those clients appear by phone. This can be good for clients who are also scared of going to court and who don't want to see the other party in person. Also, judges will want to see that recent abuse has occurred. And at my organization, we like to focus on elder abuse that's happened in the past 3 months. There's a space on the restraining order form, the request form, where you list the most recent thing that happened. And then there's a space below it where you can list all the other things that happened in the past. So you'll want to make sure that something recent has happened, because that's what the judge is going to care about the most, probably. And so for those of you who work with victims of elder abuse, maybe you've heard of the Elder Abuse Prevention Project. There are a lot of local organizations that participate, including the district attorney, Adult Protective Services, Meals on Wheels, so if you, etc. So if you have a client who's a victim of elder abuse, you can refer that person to any of these organizations as you feel is necessary. And if you have any questions, feel free to reach out to us. If you want to refer clients to us, feel free to do so. We're always happy to have anyone who walks through our door.
Well, guess what, Emily? We do have some questions for you.
Great.
All right, so we're gonna rock and roll here. First question: could you please comment on scope of discovery for elder abuse restraining order cases? And additionally, can discovery be used by abusers as an abuse tactic?
So I would say in all the elder abuse cases that I've done, there has been no discovery. And so I would say, you know, not only is the scope of discovery very limited, it's often, at least for the cases that I handle, non-existent. I don't handle very complex financial abuse cases. So for those cases, the scope of discovery might, of course, be broader. But for just your regular physical abuse, verbal abuse, caregiver neglect, we don't really conduct discovery. Like I mentioned, there's only a 3-week period usually between when the temporary restraining order and you first file for the restraining order till you have your hearing. So that doesn't leave a lot of time for discovery. Also, the restrained parties, they're usually not represented. I've never had a restrained party on the opposite side with a lawyer. And so these restrained parties, maybe they could try to use discovery as an abuse tactic, but with the unrepresented parties that I go up against, I don't think they even know what discovery is. I have seen cases where the restrained party tried to use additional litigation against the client as an abuse tactic, and filed additional cases against the client and against the client's relatives. So you might encounter that, but I would say, yeah, discovery is not something that I really do for my cases.
Okay. I'm gonna ask the next one, Samantha, and then you can ask the follow-up. All right. What if the client lives? Oh, sorry, take that back. Can the withholding of medication, such as blood pressure controlling medication, constitute elder abuse?
Yes, I would say that it can. If your client has a caregiver and one of the caregiver's duties is to give your the client's medication, and the caregiver is not doing that, I would say that definitely constitutes abuse. There might be a gray area if you have a person who is not a designated caregiver and maybe just lives with the client, like an adult child, and it's not necessarily made explicit that that adult child will help mom with her diabetes medication. And so in that case, maybe you're going to have a harder time arguing that it constitutes elder abuse. But I would say for a caregiver elder relationship, yeah, withholding of medication is definitely abuse.
All right, Emily, so we also have, what if the client lives with the abuser? How does that work?
So that's a great question. One of the things you can get with this restraining order is a move out order. So if your client lives with the abuser, they can ask the judge to order that abuser to move out of the client's house. And usually that will solve the problem. Sometimes the judge will grant a restraining order, but they won't order that abuser to move out. And then the client has to keep living with the abuser. That creates a problem for clients. I've seen that happen. Usually then I tell my client, go get that other person evicted, go seek an eviction and talk to a lawyer about getting an eviction. I have seen instances where the judge will deny the move out order, but they'll order the abuser to stay away from the client's house. And usually then the client's just totally confused, doesn't know what's going on, understandably so. In my experience in those cases, usually the sheriff declines to kick the abuser out. So unless you get a move out order, the sheriff will usually let the other abuser to continue to live in the client's house, even if the client gets an order saying the abuser needs to stay away from the house. I know that's confusing. I don't really understand why the judge does that.
Emily, back in the day, I think I had the same situation happen, and what the judge ordered was the restrained party to stay 2 to 3 yards away. So not the full 100 yards, but just 2 to 3 yards. But if you're then going to go do the eviction, it's good to have some safety. You know, you have your restraining order in place in case the eviction notice causes more tension between the parties. At least you have your restraining order as a tool if things go awry in the eviction. So the next question we have, Emily, is can an EARO be used to prohibit abusers from accessing a bank account or to block an account?
So yes, I would say that it can. That's something that you could try asking for in the additional orders section of the restraining order. Depending on what's going on, sometimes there might be other issues, like the client might have willingly added the abuser to the bank account, or they might have a power of attorney that gives the abuser that power. So you might want to dig around and look at, for instance, whether there's a power of attorney there. But yeah, you could ask for that in the other orders section of the restraining order.
Great. Doug, go ahead.
All right. Who determines if a person lacks capacity to testify?
That's a good question. Usually, at least at my organization, we usually don't really bring in that many witnesses in our case. Usually, if anyone lacks capacity, it's likely to lack capacity. It's probably maybe going to be the client. And in that case, if a client who lacks capacity comes to us, we would just decline the representation. But I would say that if for a person who lacks capacity, I had a case where there were questions about the client's capacity. In that case, we had the client's agent under a power of attorney. So the client's attorney, in fact, be ready to testify and come in and say, yes, you know, client wants this restraining order.
Gotcha. All right, how likely are judges to award attorney fees? And
Uh,
how do the judges determine reasonable fees?
So I can honestly say, I've never asked for attorney's fees, so I'm sorry, I don't know how likely judges might be to award attorney's fees. Sorry about
Okay.
that.
Have
I've
you
seen
seen
judges request fee waive, like a schedule of the attorney's fees, and they may set up another hearing to hear it. I've seen that happen before. I can't say it always happens, but there's a request for attorney's fees. Sometimes the judge will ask for supporting documentation regarding the fees and may set up a hearing for it to make sure it's reasonable.
Yeah, I'm actually dealing with that right now. And we were successful in defending a restraining order. And I requested it at the trial to for fees, and then the judge said, yeah, do a notice motion. So notice motion, give a memorandum of points and authorities, my billing, what it was comprised of, gives everyone an opportunity to object, etc.
So Emily, another question is follow up to the abuser living with the client. Does it matter that abuser pays one bill at that residence? Does that mean they cannot get them evicted?
So it doesn't matter. It's abuser could pay rent, abuser could pay a bill. You can still get abuser or to have abuser ordered to move out. You could also have it where it's a husband and wife who own a house together and husband is the abuser. You can get a judge to order husband to move out even in that circumstance.
Okay, our next question is, what about TRO when abuse is solely via incessant text, phone calls delivered by adult child who knows how to hide and relabel phone ID, an older adult not savvy enough to distinguish between legit versus bad calls, so answers the call? Just tell them never to answer the phone?
So yes, I sometimes will tell my clients, don't answer unfamiliar numbers. Anyone who really wants to talk to you can leave a voicemail message and you can call them back. But I would say that kind of incessant calling and texting, I've seen that with clients, and judges do accept that as constituting abuse. So if that's going on, that's definitely something to put in a client's declaration.
Great. Doug, you want to do the last one?
Oh, sure. All right. If a caregiver files for, excuse me, an EARO, prepares it for the elder to sign, just to isolate family, but TRO is never served, no one showed at court, so order is denied, does family member have any way to expunge the TRO or get it off record?
So, yeah, I had a case where the respondent, the abuser, wanted the case expunged. In that case, yeah, you can do that. The judge said that the abuser in that case could do that. But I don't know what the process is for doing that.
Sounds like maybe a masking order of some kind.
Well, Emily, I want to thank you on behalf of everyone, because you spoke for so long that they don't have to hear me speak. And I am sure every participant is jumping up and down doing a happy dance. So thank you for them.
Okay, so I'm going to run the poll.
Oh, yes.
And if I think, I think we should give them a little bit of an option if they want to listen to you for a few minutes, Doug. Maybe, does everybody know how to raise hands? Raise your hand. Well, can we see that? I'm going to run the poll really quick. Doug won't take it personally if you don't raise your hand. Do you guys all know how to do that? See, I can raise my hand. Oh, we have one. Oh, people are raising their hands.
No, they aren't. Don't.
Look, I'm not kidding you.
Sorry, Ann, your credibility is suspect in my eyes.
Dude, look on the part. Can you confirm, Samantha?
Sure.
Look at the participants.
Well, I'm trying to,
You have
host the
5
panelists,
people
not
want to
vote.
listen to you. Craig doesn't count.
Yeah,
But maybe Doug, we could just talk about ideas to consider when dealing with cases where we have elders who are considering divorces and the different issues we can run into.
Emily, is that okay with you?
Of course, go right ahead.
You were my last out.
Sorry.
That's okay. Anne, are we able to, did we get
Yeah,
enough?
we've got, I mean, it's 5 to 7. If you want to, you know, if people, you can all have your certificate at this point. So if you want to leave, feel free, you will get your certificate. If you would like to stay and hear more from Doug, that would be great.
I don't know why anyone would want to do that. So I suspect that the
We'll let
participant
Doug-
number
We'll let,
is going to drop. There it goes. Keep going. Down to
we'll
4.
let Doug go for Doug for 10 minutes, 15 minutes.
Yeah, we'll go for about 4 minutes. All right.
Okay.
No. So I was talking to Samantha, excuse me, given that, you know, our other speaker, you know, ultimately was unavailable, and we were discussing kind of what issues arise in our practice when we're dealing with elders, and there is a divorce or a pending divorce or in the process of divorce, or what happens when you have a elder who then becomes incapacitated during a divorce, and kind of we were spitballing regarding kind of these issues and whatnot. And I figured I would, I've had a few scenarios. So early on, I was so all of these, just so you understand, are comprised in the context of a conservatorship in some form or fashion. And they just happen at different kind of different timelines within a divorce proceeding. So in the first scenario, I was court appointed on an individual who was adamant, even though he had a temporary conservatorship, that he wanted to divorce his spouse. And so that was one area, was, does, you know, as an incompetent person, does he have the requisite capacity, and what is necessary to proceed with that? So that's scenario 1. Scenario 2 is identical to that, but it wasn't the incompetent spouse, it was the competent spouse who was initiating a dissolution proceeding, and how to properly respond and or go through that process. And then the third one was, believe it or not, 2 competent individuals who were going through a divorce, and in the midst of it, one of them had an accident and became incompetent, and what kind of occurs in that scenario. So I've had all 3. The one thing for all you probate cool cats to consider, because I am literally litigating this very issue right now, is probate code, and most of you probably already know this, but I'm late to the party. Probate code 3051, I think it's B, but essentially says if there is a competent spouse and an incompetent spouse, the competent spouse has exclusive right and control over all community property assets. And so essentially there is no conservatorship of the estate if they'd been married forever, because the surviving, or not the surviving spouse, the competent spouse has exclusive control. Now that makes it a little tricky in blended family scenarios where, you know, an individual comes in with, you know, separate property. So just know that you can kind of run into that situation, because I'm running into it right now, where there really is no estate. Now I'm fighting the conservatorship in the first place, but they appointed a professional fiduciary, and that individual has marshaled the assets. And my argument is the wife should be controlling that stuff, not, you know, not the conservator. So Samantha, do you want to, I've been talking already for 5 minutes. Do you want to jump in for little things, and we can?
Yeah, my just 2 cents on this is, my experience has been with elders outside of conservatorships who want to go forward in divorce proceedings, and kind of the issues there. touch on, sometimes I have, issues with determining what separate property is because it's a really long-term marriage and good records aren't kept. And if we're coming up on some, memory issues, not necessarily incapacity, but memory issues that can kind of cause problems sometimes. And just maybe trying to divide what assets we have between two elders who need high levels of care. How do we split up their assets and still maintain them while they're living apart? Because they certainly can't jump out into the workforce
So,
and,
yeah,
and gain money that way.
No, so here's the fundamental problem I have with family law, which is it is set up to fail, right? In the sense that under the family law, each spouse is supposed to be under the same cost of living or expectation of living that they were when they were married. But the reality is now you have twice the costs and half the money,
Right.
and it's an unreasonable expectation, right? And so, you have both these individuals who are not ever going to be at the same kind of level as they were when they were married. Just, it's incapable of occurring. And a couple of things, if you guys don't know this, if you've been married for 10 years or longer, it's considered a long-term marriage. And what does that mean? That means basically if you get divorced and there's spousal support in some form or fashion issued, it is issued until either death or remarried. Okay. If you are under 10 years and you get a divorce, you get temporary spousal support. And temporary spousal support is usually 1/2 of the years that you were married. Okay. So if you were married for 9 years, someone is going to pay temporary spousal support for 4.5 years. But then it ends. There's no limitation on child support. You have a duty, public policy to pay for your children until they become adults. Which begs the question now, right? Is you subpoena records, you're only getting them for 7 years. Number two, most things are digitalized in records, bank statements, etc. And those are very difficult to save, etc. So if you're not on a monthly basis saving your bank statements, PDF or whatever, and backing them up, right? Doing this consistently, and then you get divorced, you're going to be SOL if you have, a legitimate separate property claim or right of reimbursement, because you're not going to be able to trace the income or the source of it. And the rule of thumb is everyone lies, prove it to me in documentation, right? And you're not going to be able to do that. So when it comes to elders, especially in this, like my big concern, and I believe this is accurate, but you need the bare minimal in capacity to get married. I mean, it's the lowest threshold is getting married, but it's a fairly high threshold to get divorced. And importantly, you must maintain that threshold of capacity throughout the divorce proceedings. And once you don't, the dissolution can't continue if you were initiated. So that's, that's one of the concerns, right? Unless the other side stipulates and says, yeah, I want to divorce you, we can, it ain't happening.
Yeah, I agree. These are just some of the issues that Doug and I have run into in handling cases that have crossover issues into family law. Certainly not close to exhaustive, but just some issues to pay attention to. Resources are sometimes limited, and what's in the best interest of the client.
Yeah, on that note with resources, I will have Ann send, or maybe I will send, but we did a MCLE spectacular about 2 years ago, or it was exactly this issue, elder law and family law crossover issues. And so there's some very good case law and whatnot that we will send out as well, so that practitioners can at least have a source to look at in order to, if they come upon this issue, they can look at this. The case laws, both family law and probate, that kind of deal with these various issues.
Sounds good. Ann, you're muted.
Got a couple questions, Doug.
Uh-oh.
What about capacity to marry and at the same time transmute all SP to CP?
Oh, some property to community property. Okay, well, you're transmuting. I think that's contractual capacity. And so that's basically the highest threshold of capacity, whereas marriage is the lowest threshold. So number one, if your if you're drafting some trust and you're going to be transmuting property, doing a real property agreement, or not a real property, but a separate property, community property, you better take a step back and have those individuals get their own respective clients for that specific issue, because you're going to have an inherent conflict of interest at that point. And you can get waivers and stuff, but it's better to say, on this specific issue, you guys get your own attorneys, figure it out. Now, you get married and then you transmute. So I guess, you can do that. And transmuting is specifically defined in the family code on what has to be done. So if you follow all those, you're allowed to do it. And now, I mean, again, if there's incapacity issues, then it's going to be on the moving party to prove such incapacity. But again, we're presumed to have it until otherwise.
Okay, looks like we are do you guys have anything else? Okay, I'm gonna say thank you to everyone, and Emily and Doug and Samantha, and we will see everybody next week. Have a great evening.
Spirit fingers.
Bye.